Welcome, everyone, back to our SERMAPod. This is our every other week podcast on all issues involving risk, law, claims, insurance, involving the sports and entertainment industry. I am the CEO and founder of SERMA, the Sports and Entertainment Risk Management Alliance, Rich Lenkov. Today we're covering a very interesting and perhaps groundbreaking lawsuit involving non-fungible tokens. We've got an expert on this subject, someone who recently wrote an article in Forbes about the Quentin Tarantino versus Miramax. Miramax actually is suing Quentin Tarantino. Neil Elan. Neil, welcome to the podcast.
Thank you for having me. Appreciate it.
Neil's a senior counsel at Stubbs, Alderton and Markiles. His practice consists primarily of business, commercial, and entertainment intellectual property litigation in both state and federal court. Neil's particularly knowledgeable about the technical aspects of NFT transactions and primitives on different blockchains, including Bitcoin, Ethereum, Solana, Tezos. He works closely with prominent NFT artists, collectors, and creatives, gives presentations to businesses on NFT technology and legal issues, and has been involved in the NFT space since 2020. So, Neil, I'm a huge Tarantino fan, huge fan of Pulp Fiction. Tarantino almost famously hand-wrote this script for this movie back in the early 90s. Came out in 1994. He made a deal with Miramax to distribute his film. And fast forward to today, where Tarantino was one of the most prominent directors, artists to announce that he is intending to sell pieces of this piece of art, specifically parts of this handwritten transcript. I think he announced that he was going to sell by auction 7 different segments of this handwritten script. Very notably, I mean, one of the most popular films in the last, 40, 50 years. I think he won the Oscar for screenwriting for that film, if I recall correctly. So obviously a very important piece of art. In the screenplay, as he mentioned when he made this announcement, he crosses off names of characters. John Travolta's character goes from Edgar Vega to Vincent Vega. He makes corrections, all in Tarantino's own handwriting. So obviously a very personal piece of art. Many liken it to a Picasso or a Rembrandt. Miramax, who contracted with Tarantino to release the film, says not so fast. You don't have the right to release that and sell that. That's part of our property and part of the contract that we made back in the 90s. Pick it up from there, Neil.
Yeah, so that's exactly what is going on. And so in 93, 94, a series of license and related agreements were entered into between Tarantino, his production company, and Miramax. And like any contract, those set forth the parties' rights to distribute, to publish, distinguish between rights to the screenplay, rights to the film. And so at the time, obviously, NFTs were not a thing. And so fast forward to present day, well, the question becomes, did Tarantino have the right to launch the NFT? And just let me rewind for about 30 seconds just to give everyone kind of a preview. What is an NFT? An NFT is a non-fungible token. And it's this digital property right, this authentication, this certification on a blockchain that can be private or public. And it says, I am the owner of this. You can think of it like a digital file. And with the NFT, everyone can immediately see who owns it, when they acquired it, what wallets it's sitting on, what they're doing with it. And so Tarantino launched this in collaboration with another party, Secret Labs. They launched this NFT. And this NFT was a collectible. Think about it like Pokemon cards, or if you're a Star Wars fan and you really want that Darth Vader mask. So who would be purchasing this? An enthusiast who would want it for sentimental reasons or collectability reasons. And so the NFT contained some portions of his handwritten scripts, handwritten notes, some audio and visual files, some commentary from him as to what was going on in his mind at the time of writing the script. And so Miramax said, not so fast. We have the right under the contract. So what does the contract say? Well, the contract says that most of the rights were given to Miramax. Tarantino granted most of the rights to Miramax in terms of production, development, all rights to the copyright and trademark. And Tarantino reserved some limited set of reserved rights with respect to print publication, screenplay publication for books and comic books, whether in electronic or regular printed form. And so Tarantino says, wait, I have the right. This is a screenplay. These are my handwritten notes. And so it falls within my reserved rights. And Miramax says, no, because you're borrowing from other aspects of the film, the motion picture that we produce, and we have the rights to in terms of copyright and trademark. And so the dispute concerns and centers around the issue of whether this NFT falls within Tarantino's right to commercialize print publication of the screenplay.
Yeah, I think, Neil, thank you for that excellent summary, by the way. So one of the key questions, I think, will be, what is the definition of publication, right? I mean, traditionally, how have courts looked at that term, and how do you think they'll apply it here?
Yeah, and so this comes up, this is a recurring theme in any contract dispute. This happens to be an NFT, but in any case, the court really wants to know what were the intention of the parties. And so the court's going to the judge is going to put himself in the shoes of the parties in 1993. At that time, NFTs weren't a thing. And so at that time, print publication usually meant, well, what if someone wants to write a sequel? What if Tarantino wanted to develop a new character? What if Tarantino wanted to use a character from the screenplay that he wrote and create a book, a children's book, a comic book? And so from that perspective, which has been emphasized by Miramax, it arguably may not lend itself support for the position that it is within Tarantino's right because it wasn't contemplated at that time. And so that issue of interpretation and kind of what the parties intended at the time is one way to look at it. It's not the
By the way, a children's book version of Pulp Fiction is right up my alley. Forget all the ABCs and fairy tales. I want more of the wolf. I want more bloodshed in my kids' books. So the intent of the parties is really interesting, of course, because we're trying to apply concepts, intellectual property concepts that are very relevant today and growing in relevance to the early 90s. And as you've said a couple of times, that wasn't a thing. So how do you think the court will look at the intention of the parties in drafting this contract when it comes to this idea that literally wasn't even in existence when they drafted it? I mean, that's a really difficult endeavor.
Will courts start with the four letters of the contract? So what does the word mean? What does print publication mean? And so from that perspective, it means the right to develop content based on the screenplay. And so his handwritten notes probably would fall within that language that Tarantino might have the right to launch the NFT. But to the extent that the NFT incorporates other audio and visual aspects that are borrowed from or are derived from the motion picture, it gets a little blurry and fuzzy. And so the court is going to want to look at the actual definition, and that term is not defined in the contract, but based on custom at the time, the judge will get a good feel as to what exactly print publication and screen publishing means, screenplay publishing means. And then from that, the judge is going to have to analyze the NFT and kind of come up with a diagram as to what elements are in the NFT in terms of audio, visual, screenplay, and then make a determination based on that.
How relevant is the fact that this is, not a prop or something, or not a trading card, but this is a work of art, unquestionably in my mind, no different than a painting or a sculpture. This is something that Quentin Tarantino, again, many people like him, many people don't. I think he's one of the great directors. Sat down in LA, many years ago and hand wrote. And how relevant would it be the fact that literally he, this reflects changes on the fly and his own impressions and some artwork. versus just something that maybe someone else created. The fact that it's very intimate from this artist has to be relevant.
It's not irrelevant, and it does come into play. And he kind of, Quentin Tarantino stages the case as Miramax trying to bite the hand that fed them. So a reflection of his kind of creative outlet, his mental impressions. But at the end of the day, even if you're a creator, you enter into a contract, and for society to function, we have to rely and give credence and full faith and credit into these contracts. And so it does come into play, but to the extent that the NFT did incorporate portions that were assigned, IP portions, IP rights that were assigned to Miramax, then I don't think the judge would overlook the fact that it reflected Tarantino's creative impressions while ignoring the four letters, the four corners of the contract.
Neil, very profitable film, was made for about $8 million and has grossed worldwide to date about $220 million, somewhere in that range. How much of a factor is that? Number one, obviously the fact that, there's a lot of money at stake means that the parties are invested, right? People usually don't sue over unsuccessful ventures. Number one, how relevant is that? Number two, what kind of dollars are we talking about? What are the damages involved in this case, given that NFTs are not something that you could put a set price on, right? It's very much a function of the popularity of the NFT and the demand for it. So maybe you could segue into that. But first, how relevant is the profitability of the film, and what kind of damages are we talking about?
Well, the profitability of the film could come into play when, based on Miramax's claim that it's causing confusion and it's leading others in the public to believe that Tarantino is misappropriating or commercializing IP that belongs to such a successful franchise, such a successful film, such successful and well-known, well-established IP. But in terms of the specific NFT, I believe that there were about 7 or 8 NFTs that were going to be auctioned, and the first one sold for about 1.1 or 1.2 million, and so the rest of them were put on hold in light of, to my knowledge, in light of the dispute, and perhaps for other reasons as well, such as kind of changes in the NFT marketplace, part of that hype cycle. I can't attribute what caused the rest of the auctions to stop, but the bottom line is not all of them were sold. So we're looking at about $1.2 million in money that was given by the purchaser to Tarantino, and however it was split with the other NFT developer launcher party. And so that's your range of damages, and it could be more, but I think that kind of 1.2 million would be at least my initial reaction, not having seen any other calculation of damages in the lawsuit.
It'll be interesting to see if the lawsuit, the litigation, increases or decreases the value of the NFT, right? On the one hand, you could argue that if Tarantino is successful, then it's litigation proof and the value increases. On the other hand, anytime you're dealing with litigation, it automatically decreases the value of something. People don't want to touch it as much. But I'm interested in knowing how contracts have evolved, right? I mean, now, obviously, Hollywood studios are entering into contracts that deal with NFTs to avoid uncertainty like this. So how has the industry learned and changed contracts with artists in the NFT era?
Well, this is kind of, this is a grassroots movement right now. We're still very early. We're probably before the first inning. We're at the warm-ups in batting practice. And so I think studios are still experimenting and thinking, and a lot of these issues haven't played out yet. But definitely there has to be some recognition by the parties that a lot of IP will be created and developed through NFT technology. And so you have to take into account, well, what is a blockchain? How are rights transacted through a blockchain? How does one protect their rights? What if someone sells an NFT to a third party, but they don't know who that third party is because it's all on a blockchain, and you might know their digital wallet address, but you don't know their name. And so this issue, when analyzed in the context of how our digital lives are changing raises important questions and red flags and issues for all attorneys and creatives to kind of understand, well, how do we think life will be tomorrow, and how do we set forth our rights to provide as much certainty in light of this changing landscape?
It's a great point, and it sort of relates back to what I said earlier, that a purchaser might be buying a liability if they buy an NFT. How do I know if I buy an NFT, today? Is there a title search? Is there some kind of clarity that I have as a purchaser to know that I'm not buying a liability, that's something that someone else owns, might be subject to a lawsuit down the road? I mean, this is all, of course, uncharted territory, but how do consumers protect themselves from being sued as the owner of this property?
Well, it's not entirely clear. You buy anything subject to any claims that a third party might have over the IP, and so there's no guarantee. But you would, in many NFT transactions, there are terms and conditions and representations and warranties, no different than when you lease a car or rent something, you sign your life away. And so it would depend on what the boilerplate language as part of that NFT transaction would state. Maybe the seller states it disclaims any liability and states that he, she, or it is not aware of any third party or adverse claims to the extent there are any, unless it can be established that the seller was aware of a third party claim, then all liability or all risk would fall on the purchaser. I don't know if that would hold up in the court of law, but there are open-ended questions, and the issue of NFT doesn't abstract away from that problem that occurs in traditional pre-NFT licensing deals. I do want to add, though, that a benefit of NFT, and this is a little segue into kind of the bigger picture, is that it is tantamount to an Excel spreadsheet database. And so let's say that there's a collection of 100 NFTs belonging to Pulp Fiction. This is just a hypothetical example. And I can see, based on looking online, kind of like a Google search, but on the blockchain, I can see the smart contract address for each of those 100 NFTs that comprise the collection. And so I know if I am buying the real one that's authenticated and part of the collection, or Joe Schmo from some that is just trying to create 100 imposter ones, kind of like going to Canal Street and buying a fake purse. So because everything's online and authenticated and traceable, it does give the buyer some clarity in knowing whether he or she is buying an original.
And Neil, to that point, I mean, what do you get if I purchase this NFT from Quentin Tarantino and I own, the part of the script? I understand. I see a tangible thing. It's a script with notes on it. What else do I own in addition to that? In other words, what are my rights upon possession of this, in this case, pieces of paper?
Well, it would depend on the terms and conditions and the scope of the license granted, whether the purchaser would have the exclusive right to that to exploit it, or maybe they would just be given a license. So that would have to be spelled out in the NFT, what the purchaser can do with it, and what the seller, whether the seller has any reserved rights and what the extent of those rights are. Could Tarantino then come out with part 2 of a NFT launch collection and use elements from that part 1? It would have to be spelled out in the contract. Generally, for copyrighted works, the purchaser has a license, and the original seller, the creator, does retain much of the IP rights. And so in the absence of anything spelled out contrary, that would probably hold true here. But what else you can do with it? Well, everyone thinks of NFTs as kind of the speculative investment. And given where we are now, that's how a lot of people view it. I don't necessarily think that that's where all of the business entrepreneurial spirit is going to go in the applications. I think there are going to be networks built around these. And so what if Tarantino in 5 years come out with another NFT collection and he wants to create a fan base? He doesn't have to go to a studio or some talent agency to really be able to interact with his fans. What if he can instead say, you know what, everyone who holds one of my NFTs can now vote as to what screenplay I should write next, or can now be featured in my next film. And so what it is it in theory, and depending on what the creator wants to do with it, it can create this aligned incentives and this direct relationship between the holders and the creator.
What's the status of the lawsuit currently, and what do you expect to happen with it? I mean, it's hard to predict exactly, but let us know your thoughts on that.
Yeah, so the trial is now scheduled for late February, I believe, of 2023, February 28th, if my memory serves me correctly. And the parties are in the process of settlement discussions. Whether it will settle or not remains to be seen. But to the extent it does not settle, then the parties will have to push full steam ahead and prepare for trial. And there is a pending motion by Tarantino seeking to knock out the case on the basis that, as a matter of law, Miramax does not have a claim or a case because all rights were assigned to Tarantino.
Neil, finally, any other interesting cases NFT-wise in the pipeline?
Yeah, there are a few. There are about, I would say, about 5 or 6 cases that many NFT attorneys would know about in the space. One that comes to mind is Hermes is suing an artist who created these digital meta Birkin bags, a play on the Birkin bags, and Hermes is claiming that the artist didn't have the right to do that. And so the issue in that case is whether it violates the trademark and whether the artist is selling it as a digital wearable, or in the alternative, whether the seller is making some political or social commentary. And it would be, if that was the case, it would be more likely that it would be permissible. And so that's one case. Another case is Nike is suing this online retailer called StockX. And what StockX does at a very general level is it's a platform where people can resell items. And so it adds a layer of authenticity. And so if you own shoes and you want to sell through my platform, you send the shoes to StockX. StockX has a distribution retail, a physical plant center somewhere, and they verify, authenticate that it's accurate and correct and not counterfeit. And then they give that stamp on its website so a third-party purchaser can know that it's authenticated and legitimate. And so what they did was to kind of add that layer of comfort. They created an NFT for each shoe that was sent to them and sold on their marketplace. And so the NFT corresponding with one of the Nike Air Jordans, Nike claims that that's infringing on its IP rights. And StockX is claiming, no, this was just part of the authentication process. We're not actually selling anything belonging to Nike. We're just kind of giving it a check mark or a stamp saying that this is what it says it is.
It's Neil Elan, Senior Counsel at Stubbs, Alderton and Markiles. Also, check out his excellent article on this very subject on Forbes.com. And to all of our viewers and listeners, I'll remind you to say what again? Say what one more time? I dare you. I double dare you. That's, of course, a great quote from Pulp Fiction, one of many. Neil, thank you so much for joining us on the SERMAPod. Please come back and update us on this very important case.
Absolutely. Thank you. Have a good day.
Ideas, strategies, and opinions represented on this podcast are those of the speakers and do not represent the ideas, strategies, and opinions of their employers.